And I think it threw them off their game because let me tell you, Chris, not once did law enforcement say, hey, where were you driving from that night? Did you have anything to drink that night? Can you believe that? They never asked whether or not my client had anything to drink.
You're not going to win on side of the road. I tell people all the time, you're not. You're just not going to. I can't win on side of the road.
Oh my God, I knew I shouldn't have drove, right? I've heard these calls and I'm like, you are just digging yourself deeper in the grave.
The warning you get that the calls are being recorded is real. They are really recording you.
I think prosecutors get so caught up in thinking, oh, this one's going to resolve. This one's going to plea out. And I just think that they failed to go get that additional evidence. I think that they thought that they had enough. But I also think that that's some of the pitfalls with the job as a prosecutor as well. It's because ultimately, whether you're a prosecutor or a defense attorney, certain evidence either needs to come in or stay out for you to make your arguments and close an argument. So that's why I want to start there and then figure out, okay, if these are the things that I want to say and these are the things that I want to argue in closing, what do I need to do throughout the trial to give me the opportunity to say that to the jury, to argue that to the jury, to sometimes beat the jury over the head with it in closing arguments. So
if you work backwards, you kind of know what you need to do at every phase to be able to say what you want to say in closing.
If this trial truly was about who is the greatest NBA basketball player of all time, Michael Jordan or LeBron James, I personally would not be a good juror for that trial because I don't care what evidence is put on. I don't care what testimony comes out. I don't care who takes the stand. I cannot be persuaded otherwise. And then, so I lead into it and I say, so members of the jury, just like I wouldn't be a good juror for the trial of who's the greatest NBA player of all time. Does anyone here feel with the charge of DUI that this might just not be the best trial for you to sit on?
I'm still in that also. I'm going to use that as well.
I think it's because DUIs are one of the most common crimes that not only people commit, but that also are talked about on the news.
Welcome to the Iron Gavel. I'm Chris Washington, a criminal defense attorney with over 17 years of courtroom experience. Bi-weekly, we bring you gripping true stories of justice, strategy, and humanity from inside the courtroom. Today, we explore not one, not two, but 3 DUI cases where our guest and hero, Paul Aloise, received not guilty verdicts. Let's uncover the truth together. Paul honed his skills working as a felony prosecutor where he tried over 50 cases in 3 short years. That's a lot of trials. Averages out to more than 16 trials a year. For any practicing lawyer, that is a lot. After that brief stint, Paul immediately joined a firm where he practiced both civil law, personal injury, and criminal defense. He's now a member/shareholder in the firm of Rubin and Rubin, where he continues to fight for justice in both criminal cases and civil cases. But before we unpack the courtroom drama, let's get to know the person behind the fight. So, Paul, what inspired you to pursue a career in criminal defense?
Definitely from a young age, it was something that I was always interested in. And I always tell this story to friends and family. And it's somewhat a joke, but it's also true. You know, I'm Italian. I grew up in an Italian family. So a staple, I think, in most Italian families is watching the movie My Cousin Vinny growing up, right? And, you know, in that movie, Joe Pesci is playing a criminal defense attorney representing Ralph Macchio. And it's what's funny is then when I was at FSU Law, they actually show that movie because so many of the courtroom procedures are much more accurate than a lot of other movies and TV shows that everyone watches. So that was definitely something that piqued my interest early on. And then when I was actually in undergrad at FSU, one of my 2 majors was criminology, the other was sport management. So again, still following that same path of my interest in sports and crime. And ultimately, I started working at a criminal defense firm as an intern. And both of the attorneys that were at the firm at that time were both former prosecutors and just were 2 guys that I felt I could connect with both professionally and personally. And that really helped guide me. And then once I was in law school, after having been, you know, an athlete all my life and having played football at Florida State, the moment I had my first mock trial, trial team competition, I just immediately felt that same competitiveness and that opportunity to make a play, right? That ability to really help somebody and that teamwork with a co-counsel. It's like playing sports. So somewhat of a long-winded answer, but I think there was a combination of years of reinforcement of different things popping up that really drove home what I knew I would love to do long term.
That's usually what happens. Our competitive nature as kids grows into this is a profession where you can continue to be competitive. Where did you grow up and how did that shape your view of justice?
So initially I grew up in Boston, right outside of Boston, West Peabody, Massachusetts. And then we moved to South Florida when I was about 8 years old. And so having grown up in Boston and moving to a smaller, less hectic, right, more of the suburbs in South Florida when my parents wanted to get away from the city, I think gave me two different perspectives. Because even though I was 8 years old when we moved down here, most of my family was still up in Massachusetts. So every summer we'd be going up there for about a month. And my dad was the youngest of five. So I was kind of the youngest cousin out of everybody. So just growing up around individuals who grew up in a city, I would hear about different things going on there. And then coming down here to Florida, obviously saw a whole different view, kind of living more in the suburbs of Martin County. But then playing sports, again, it put me in front of a lot of different people from a lot of different areas. And so I think my background of living both in Massachusetts, South Florida, and then playing a wide variety of sports really helped me connect with a lot of people. And as you know, as a trial attorney, right, our ability and our strengths and sometimes someone's weakness is their inability, right, or their ability to connect with jurors, with witnesses, with clients. So I think that has really shaped my ability to practice in all types of courtrooms, on all types of cases, and represent all kinds of people.
Having a diverse background actually helps you be a much better attorney because you can literally walk in a room and talk to anybody. So what's your mission in this line of work?
When I was being interviewed, when I was being poached from the state attorney's office to come into the private sector at my first firm, which was Brooks LaBeouf up in Tallahassee, the managing partner asked a similar question. And I think my answer still stays the same is, when someone's going through a trying time in the community, I want to be the person that they call for help. And as cheesy as that might sound, as cliche as it might sound, I don't even mean that I can necessarily help everybody, but I want to at least be the person that they call that they know that they can trust for a referral to maybe another attorney, right? Like, I don't really do a lot of real estate matters, right? But if God forbid someone has something going on with their home, I want them to feel comfortable. Like, all right, I know I can call Paul and he's going to help get me in the right hands. So that's why both the civil practice on the plaintiff side, right? Someone's been injured. In the criminal defense world, someone has gone through a horrible situation. Sometimes they have been physically injured, like we were talking about, even before we got on the podcast here today. But sometimes their life is actively being damaged, right? So I see myself helping people in both matters. And while they're in different lanes, we're still striving for the same goal, which is to get the best result for the aggrieved party.
I always tell people, especially my kids, I have small kids, so they'll ask what I do. I'll tell them I help save lives, kind of like a doctor does, but in a different way.
I like that.
That's literally what we do in criminal defense and in personal injury, because when somebody gets injured, their entire life is disrupted. So I'm helping to save it or restore it as best I can anyway.
I'll say this, though. My younger brother's in his second year of residency down at Mount Sinai as an emergency room doctor, so I can't really use that same line, like I'm really saving lives, because my brother's like, no, last night I actually saved 5 lives last night.
That's right. It's all relative. So what's one thing you would say people often misunderstand about what you do?
I think it's the fact that so many people think that criminal defense attorneys are trying to get people off, and try to get these guilty people off on a technicality. And I look at them all the time and I'm like, well, first and foremost, no matter what you have been alleged to have done, right? And that's the key word we always talk about, right? Whatever they've been alleged to have done doesn't mean that they don't still have constitutional rights. And that doesn't mean that they still don't get the right to a trial by a jury, that the right that they have to competent counsel, right? So I'm a big believer of everybody has the right to put forward a defense and to make sure that the state is held to their burden of proving beyond the exclusion of each and every reasonable doubt that they did actually commit the crimes that they are being alleged to have committed. So I also tell a lot of individuals, again, it's not us getting it off, right? Sometimes there's cases that, as we've talked about before, unfortunately, the deck might be stacked against us, right? From an evidence perspective. Sometimes even the circuit or the county that the case might be in, right? Regardless of the evidence, it's like, oh my God, this judge in this circuit's going to be extremely stacked against us. The jurors or the potential jurors are going to be stacked against us. So it's also ensuring that the client and the client's family is being told exactly what's going on each and every step of the way so that they feel more comfortable that their rights are still being protected and that there are not going to be any missteps, whether it's from law enforcement at the inception all the way to sentencing from a judicial standpoint. So sometimes we're here not just to litigate and take something to trial. Sometimes it's to mitigate and try to bring that individual to life to the prosecutors, and then make sure that we are getting the best results and that all avenues of relief are being explored.
I always tell people, I can't promise you no jail time. In fact, I'm prohibited from doing that. That's against the rules. But depending on the situation, if they have you on video, my goal is not to walk you out of here. My goal is to minimize the amount of time they get to keep you in prison. We just have to tell people that up front. Otherwise, a lot of people think if I hired a lawyer, that means get out of jail free. No, not necessarily.
100%. Setting reasonable expectations early on in the process is huge.
So what do you think sets you apart in this practice area?
I think we kind of touched upon it earlier, which is just my overall ability to connect with a lot of people from a lot of different walks of life. But then on top of that, like truly my passion for the work, which I think comes in two different forms. One, from the competitive nature that we talked about, but also genuinely my sense of wanting to make sure everyone feels that they have hired the best attorney, right? And that is sometimes an impossible standard to live up to, right? Because as you know, we can file the right motion, we can ask the right questions on cross-examination, but a jury might just feel differently, right? And so that was a hard process for me to overcome from a competitive standpoint and from trying to give the best deliverables to the clients at all times. Was early on in my career as a prosecutor when I would feel like I did everything I could. I would go to trial, and as a prosecutor, right, back then I was trying to get a guilty verdict, and the jury would come back not guilty, and I would just be so mad at myself. And then I started to realize, as long as I did everything, I got all the evidence into the record, I asked all the right questions, I put a closing argument that I felt was passionate, I had to understand that at a certain point, it's out of my hands, right? So I think that's what really has driven home my success early on in my career and the ability for clients and other attorneys to refer me, just that they know that I really care and I'm going to strive for the best results, not just for the client, but because of the competitive level I hold myself to.
The 3 DUI cases that you're going to talk about today, why do you think it's important for the public to know about these cases?
I think it's because DUIs are one of the most common crimes that not only people commit, but that also are talked about on the news, right? When you're driving down the highway, drive sober, get pulled over, right? They have all these catchy cliche signs. But I think a lot of people just drive by them. They're not really thinking, oh, this could be me someday if I don't do the right things. And, I know every state has slightly different laws, but at least here in Florida, the penalties, even for a first-time DUI, are severe. I mean, it is a mandatory minimum sentence that if you plead guilty, no contest, or are found guilty at trial for a DUI, you have to have an adjudication of guilt on your record. So automatically, even if you have no prior criminal history, normally you're allowed to get a withhold of adjudication that first time, or maybe diversion. Not with a DUI. You have to have that adjudication of guilt, which prevents you from sealing or expunging your record. And then it also causes driver's license suspensions when, again, people don't really realize how much they rely upon their vehicle and the ability to drive until they can no longer do it. So I think those are some of the main reasons why people should understand both the severity of it, not only from the perspective of how it impacts themselves, but the danger that it can cause other people on the roadway.
One final question before we dive in. What are some common mistakes people make when they first get arrested or detained for a DUI?
Making jail calls and talking about what just happened. Oftentimes, obviously, everyone knows, oh, I get my one call, I get my one call. Well, that call should be for someone to bond you out, and that should be the only thing you were talking about on that call. Not, oh my God, I knew I shouldn't have drove, right? I've heard these calls, and I'm like, you are just digging yourself deeper in the grave. So I would say talking too much on those initial jail calls when they're being detained. And then I would say the next biggest mistake I see people make is oftentimes they're placed on pretrial release with drug and alcohol testing conditions. Well, they're stressed out. They got a lot of things going on. Maybe they have a drink. Maybe they smoke some marijuana. And then they have a positive test on their pretrial release. And then that causes them to violate their pretrial release. And now they're hauled back into jail. And now when they're being held no bond, the prosecutor has all the leverage, all the power, because now my client wants to get out of jail ASAP. But they're like, okay, yeah, they can get out of jail ASAP, but you're taking this guilty plea to the DUI. And then so it's that balancing act of the client, which I hate, which is, hey, we can file a motion to reinstate pretrial release. We don't know how that's going to go. But on top of that, if we're going to fight this case, and I'm always down to go to trial, we can do so, but you are going to be in custody while we're prepping for this case. So I would say those are the main two mistakes I see people commonly making.
Just to touch on those two, the warning you get that the calls are being recorded is real. They are really recording you. And the other thing you said, one of the easiest ways to get an innocent person to plead guilty is to say, hey, you can get out of jail today, or you can get out of jail this week. And if they've been sitting there, they just want to get out. And a lot of times they'll plead guilty, and prosecutors know that. That's why they fight to have high bonds and fight to violate people as quickly as possible. So there we have it. Let's jump into this first case. If you had to give a 30,000-foot overview of case number one, tell me about it.
Yeah, so case number one involved an individual who had fallen asleep in a McDonald's drive-thru and at some point or another accelerated into the car in front of him, which then caused that car in front of him to hit the car in front of that one, right? So it ended up being a 3-car accident. And don't you know it, law enforcement happened to be in the bank parking lot right next to the McDonald's and saw the whole thing. And so as soon as law enforcement saw that, they went over, made contact with my client, the other 2 drivers. And really at this point, this is where the DUI investigation sort of begins. But I say sort of, and we'll get to it later, so I know we're just kind of doing a brief overview. In Florida, there's something that's called the accident report privilege, right? And so if you are going through an accident investigation, right, and through that accident investigation, officers are asking you questions, and even if you're saying incriminating statements during an accident investigation, all of those statements are privileged because they want people in Florida to make truthful statements as it relates to insurance, right, and who's at fault. But if you don't change that hat and say, all right, I've stopped doing my accident report investigation, I am now conducting a criminal investigation, and now you get those statements again, those statements are not admissible in court. And I think that there was just so much frustration between the officers and my client during that accident investigation that they did not follow all the steps that they needed to subsequently about asking these appropriate questions. And ultimately, my client, refused to do anything, right? He didn't want to talk to him. He didn't want to even sign the citations, which again, that actually is a criminal charge here in Florida. So he was charged with that. They charged him with resisting. And then, he ultimately refused to do any field sobriety exercises and refused to provide a breath sample. And so whenever we have what's called a double refusal, a refusal of both the breath and the field sobriety exercises, I already feel like I'm maybe a field goal ahead, or maybe I'm up 3-0, or maybe if the state normally starts up 7-0, now they're only up 3-0 because that's just less evidence that they have to put in their case in chief, and obviously it's their burden. And so when they don't have some evidence, that is something that I argue as a lack of evidence, which causes reasonable doubt. So that's kind of the first case.
So in this case that occurred at McDonald's, what was your client subsequently charged with?
He was actually charged with 2 separate counts of DUI with property damage, which that's, again, something that a lot of the people in the public don't realize. They're like, oh, well, he was only driving once. Unfortunately, he committed allegedly 2 separate DUI with property damage when he caused damage to 2 separate vehicles. So he was charged with 2 separate counts of DUI causing property damage. He was charged with resisting without violence. He was actually charged with a second refusal, which I'll touch upon that in a second. But then he was also charged with refusing to sign the citations. Yeah, he ultimately had about 6 or 7 charges pending against him. The 2 most serious, of course, were the DUI causing property damage. But the other one that was very akin to those is the second refusal. So in Florida, when you're arrested for a DUI, law enforcement has the ability to ask you to provide a breath or urine sample. And part of DHSMV rules and regulations here in Florida, when you get your license, right, driving is not a right, it's a privilege. So that's how Florida views it. And Florida says if you're going to have a driver's license, you're consenting to a lawful test of your breath or urine when an officer has probable cause. And so you're allowed to refuse to do that, right, anytime. Ultimately, you're not required by law to provide a breath sample or a urine sample. It is voluntary, but there are consequences with that. And so the first, obviously if you refuse it, you automatically have a 1-year driver's license suspension, right? And so I talk about that with my clients all the time, but sometimes that's a necessary evil by not providing additional evidence to the state, right? So I don't necessarily think it's a bad move for someone to do, but when you do it a second time in your life, you then are charged with a second refusal, which is an additional first-degree misdemeanor charge. And so that's another important charge that is tacked on with a lot of these DUIs. And not every state attorney's office does it that way, but the state attorney's office down in Palm Beach County in the 15th Judicial Circuit has routinely done that and even did it when I was prosecuting there.
So with all these charges and even including the second refusal, how much time was your client facing?
Well, due to prior criminal history, he was offered, I believe the first offer was 9 months jail. And then from there, we were able to negotiate it down. I think the best and final before trial was about 6 months jail. But ultimately, one of the major things that we already talked about was the driver's license suspension. And that was going to completely derail his ability to make ends meet for his family. He was the provider for his family, along with his mother, along with his sister. And so he needed that driver's license. And so he was facing serious jail time, but also with that many number of charges, consecutive probationary periods and multiple driver's license suspensions.
What was his emotional state like when he first came to see you? How was he?
He was nervous, right? I think that's the best word. He felt like he got a raw deal on the side of the road when he was initially arrested. But he also, like I said, had criminal history, had been through the system before and understood some of the pitfalls that the system just inevitably has. And so he was nervous, but I think as we continued to work with him and show him that, hey, not only do we have your back, but I'm pointing to specific moments in these videos, and I'm pointing to specific sections of this DUI investigative report that really are extremely favorable for you. And while you are taking a risk by going to trial, we haven't gotten a good enough plea offer for the risk to outweigh the reward. So he started out nervous. Actually, I'll say this, even when the jury went back, he was proud with our performance, but he was still nervous. So I don't think he had a sigh of relief until after the verdict came back.
I can understand that. Let's jump into the evidence. What was some of the initial evidence turned over by the prosecution, and if any of it was problematic for you, how did you deal with it?
Absolutely. So I would say it was pretty standard evidence that was turned over, which included body-worn camera videos from the officer, dash cam videos from the officer, and then the in-car video from the officer, which is obviously in the back seat when the client is being transported to the jail. We also got all of the investigative reports, any of the supplemental reports, and then we also got all of the different credentials and certifications which show that the breathalyzer was properly calibrated and kept up to industry standards. But surprisingly, there was not a lot of additional witness statements, which again, we talked about how there were two different cars which were, struck or involved in this alleged car accident. So you would think that there would have been more sworn statements written and signed by some of these witnesses, but there just wasn't. It ultimately came down to really the officer who happened to see this accident, who was in the bank next door. But again, since they weren't trailing, right, a car down 95, there was not a dash cam video of the driving pattern of the accident. So while there was video of the officers immediately thereafter, we did not have any video of the car accident. But again, it's in a McDonald's drive-thru. There's cameras there. So why didn't the state go get that, right?
I don't know, why didn't they? Maybe it would have helped your client. Their job is to go wherever the facts take them and then develop their case based on that. But I think a lot of times they decide what happened and they only search for facts and evidence that fit into that initial thought process, which is not the proper way to do an investigation.
Exactly. And I think a lot of times too, when you have multiple DUI property damage claims coming in to review, right, and then they're ultimately going to review an initial filing decision, and then they look at the criminal history, and especially if there's a prior DUI or a prior refusal, I think prosecutors get so caught up in thinking, oh, this one's going to resolve. This one's going to plea out. And I just think that they failed to go get that additional evidence. I think that they thought that they had enough. But I also think that that's some of the pitfalls with the job as a prosecutor as well. If you have 400 cases, which in a city like Palm Beach, that's a pretty normal, caseload. It's hard sometimes to put the time in like you and I do in really reviewing each and every video and listening to each and every word that's being said. Because to me, if they watched this video, they would have seen some of the things that were missing, some of the missteps by law enforcement, and maybe they would have thought outside the box, hey, let me go see if I can get some video from McDonald's of this individual driving in, maybe stopping, maybe falling asleep. You never know. It was never retained by law enforcement, never subpoenaed by law enforcement, and the state attorney's office never had it.
Taking all that into account, tell me how you developed your strategy to defend this client and how you went about defending him.
I really work from closing arguments backwards. I try to come up with my theme, right, my overarching approach to the case, and then work backwards. Because ultimately, whether you're a prosecutor or a defense attorney, certain evidence either needs to come in or stay out for you to make your arguments and close an argument. So that's why I want to start there and then figure out, okay, if these are the things that I want to say and these are the things that I want to argue in closing, what do I need to do throughout the trial to give me the opportunity to say that to the jury, to argue that to the jury, to sometimes beat the jury over the head with it in closing arguments. So that's kind of the first step. And then I also think back to my days as a prosecutor, right? And that was some of my mentors told me, hey, Paul, go be a prosecutor, because I'm a sports guy. And they're like, hey, what's the best way to build a defense? To know the offense, right? So I'm thinking about, okay, if I'm the prosecutor, how am I going to try and prove this? And then I really do sit there and write out a cross-examination that might be 6-7 pages long based on the DUI investigative report, because I want to go through all of it. Now, I'm not saying I ask all those questions once I'm in trial, but literally writing out question by question of the entire report helps me really take in the report, understand the pitfalls, and then a lot of times, the state's asking those questions on direct. Okay, I don't need to touch that again, or I just need to follow up here. But then I also go through each and every video, and then I start writing down timestamps of either good behavior or good moments from my client, or bad behavior or bad moments on behalf of law enforcement. And then I try to kind of intertwine my cross-examination questions with these time-stamped video portions. And I think from there, that's when I kind of fall back on my training and experience. And oftentimes, man, I'm sure the same happens to you. I'll be sitting in here working through that, and I'm like, boom, that's the theme. I know that is what I want to say as my opening line of opening statements or closing arguments, and it starts flowing. And that's where I think a lot of times, you see different documentaries, right, maybe about Dr. Dre and some rappers who come into the studio and they're just talking. They're just having fun, and boom, ideas are coming, right? And I think that's a similar process for trial attorneys. You get a couple people in a room. Maybe I'm talking to a managing partner. Maybe I'm talking to a paralegal. Maybe I'm calling my boy in Tampa who's a criminal defense attorney, being like, hey, man, what do you think about this? Just having those juices flowing really sparks the ingenuity and creativity.
I like that. Starting from closing argument and working backwards. It kind of plays a lot. I'm not sure if you're familiar with cross-examination science by Posner and Dodd. I always tell people that's the Bible on cross-examination, to encourage a cross-based case preparation. But I actually like the idea of starting with my closing argument, because if you work backwards, you kind of know what you need to do at every phase to be able to say what you want to say in closing. So with case number one, tell us what your plans were for closing. And then after that, we're going to jump to jury selection, where I'd imagine you began executing that plan.
Absolutely. So for closing, which is kind of going to probably shock you, because even though I say I start with closing, I will never write out a closing argument in its entirety, right? But for the listeners, right, that's going to be kind of surprising. And you just can't. There's so many variables that are coming into play. So I'm going to come up with some type of hook at the initial close that is going to be the same hook for my opening, right? So I say something that catches their attention. And then I have a skeleton of what I'm going to work through, such as far as talking about what the state's burden is, highlighting that they have failed to meet that burden, documenting and telling them how high that burden is in relation to other burdens, right? So I'll always talk about, beyond a reasonable doubt is one of the highest burdens in the justice system. You have probable cause to make an arrest. You have preponderance of the evidence in civil world. You have clear and convincing, which is what the state needs to be able to prove to take your children away. And members of the jury, even above that burden of proof to take your children away, that's beyond the exclusion of each and every reasonable doubt. I normally go through by witnesses. Like, I'll tell a story, but then I normally dictate by talking about the witnesses in succession to the jury, because I feel like that's the best way that they've taken in the evidence throughout the trial. That's the way their notes are likely written, if that judge allows them to take notes. And I'll work through there. And then at the end of the closing, now also I move about the well a lot, right? So I'm definitely a little bit more of a performer. That's what most of my colleagues say. Hey, you got a big personality, you got a good smile, you got a rocket, right? And so I think that always helps me really catch their attention. And like criminal defense attorney, the state gets to do two closes, right? They get the first close, we go, and then they get to do their rebuttal. So what I'm also intertwining in my closing is starting to plant some seeds of saying, now listen, I don't get a second bite at the apple, but the state does. So when they come back up here and talk about X, Y, Z, please think about what I would say in response to X, Y, Z, so that I'm really trying to take the air out from that rebuttal closing before they even get an opportunity to stand up.
That's great. Case number one. Let's go to jury selection. What do you do in jury selection that you believe was impactful in the case?
Just like the state gets to go first in closing, the state gets to go first in jury selection. And when I was a prosecutor, I loved it. But now that I'm a defense attorney, I love that they get to go first, right? So I've never minded which side I was on, but the state sometimes, I think, gets caught up in the elements and trying to focus on really trying to weed out each and every individual that maybe even slightly has anything in their background which maybe got them tied up in some criminal action, just like police sometimes. But I just feel like they get so caught up in that they lose that actual interpersonal connection with the jurors. So when I get up there, I always start out with a question that has nothing to do with law. When I was in Tallahassee, normally it'd be a question like, all right, so who's here is a FSU football fan? Okay, great. Now, who do you think is the greatest Florida State quarterback of all time, Jameis Winston or Charlie Ward? If I was in South Florida, and especially when LeBron was playing for the Heat, who's the greatest basketball player of all time, LeBron James or Michael Jordan? And then I can have some fun with the jurors in regards to their answer, right? So if someone says LeBron James, I'm like, man, all right, I don't like you. You're already off my jury. I'm a Michael Jordan guy, right? You can have some laughs. But I always then tie that back into saying, if this trial truly was about who is the greatest NBA basketball player of all time, Michael Jordan or LeBron James, I personally would not be a good juror for that trial because I don't care what evidence is put on. I don't care what testimony comes out. I don't care who takes the stand. I cannot be persuaded otherwise. And then, so I lead into it and I say, so members of the jury, just like I wouldn't be a good juror for the trial of who's the greatest NBA player of all time. Does anyone here feel, with the charge of DUI, that this might just not be the best trial for you to sit on? And I think when you put yourself in their shoes a little bit, right, which again, you can't do in closing arguments, a golden rule violation, right? But when you're telling them, hey, I'm telling you, I would not be a good juror, they feel more comfortable also saying, hey, you know what, I might not be the best juror for this case because my dad had a DUI 8 years ago, and it ruined my family. We had a divorce, so I hate anyone who's even been accused of a DUI. So I think it gets people talking more, and you become more relatable to the jury that way, as opposed to yelling elements and statutes and Florida law at them.
The actual law in the law books is not that exciting. It's not very interesting. It's just what we have to deal with to be able to tell our story in court. We have to know the law and understand the rules of evidence. And look, I tell people, I didn't come up with any of this. I just watched, learned, and copied people who've been doing it longer than me. One of the things I do, before I get up to talk, I memorize everybody's name that's in the box. The first thing I do when I stand up for jury selection is ask them if they could give me brutal honesty. And I go one by one. Mr. Smith, can you be brutally honest? Mr. Turner, can you be brutally honest? Ms. Celestine, can you be brutally honest? Even if you think it's going to hurt my feelings. Even if you think I might not like the answer you're going to give. Can we all agree to be brutally honest with whatever I ask you for the time being as I stand up? Because this is my last chance to talk directly to you. My nickname as a kid was Cookie Monster, but I don't eat peanut butter. So if there was a cookie judging contest, I'm probably the perfect person unless there's peanut butter cookies. Whoever makes the peanut butter cookies is going to lose no matter what, because I don't eat peanut butter. But I do like yours where you kind of grab on something that's relevant to the community that you're in and try to use that. That's a really good idea. I'm still in that, by the way.
I think it resonates, but I love yours too. I mean, whenever you're able to kind of bring some levity to the situation, try to lighten the mood a little bit in there, I think that hits home so hard, whether it's about cookies, sports, something that people can relate to, because everything else they've heard all day, normally they can't relate to.
And this may be the only time they fully get it. Hopefully we can help them get it during the trial and understand the burden of proof. We make it through jury selection. Anything else you think we need to know about that jury selection in that first case?
I would just say not necessarily particularly that case, because I think it's going to be the same theme for all three of the ones we talk about today. I think personally, once the jury's out and you're really going back and forth with the state, truly making those cause strikes and those peremptory strikes, you got to play chess, you know what I mean? And you need to understand what the judge's rules might be for back strikes. Or, okay, are you going to go let the state pick first on this row and then the defense go the next time? You have to know that, because if you don't know the full rules of the chess game you're about to play, you might make a move that you then can't take back. So I would say that was a big factor, because in one of the other ones we'll talk about, it actually took us 2 attempts to pick a jury to get forward with the trial, and ultimately we got the not guilty, right? So even though I left mad that we didn't get a jury that day, that we busted the panel, it ended up working out in the client's favor. So I think just in general with that jury selection, understanding the bigger picture and understanding, okay, hey, we might not like this juror number 6, but if we strike juror 6, 7 and 8 were already caused. So we're going to get to juror 9, and let me tell you, I'd rather have 6 than 9, right? So it's really understanding that.
So let's jump into your opening statement. Tell us about that.
I really like to keep a shorter opening statement than a lot of other defense attorneys like to do.
I agree, because when I was a baby lawyer, sometimes I'd give these long opening statements. And then if the prosecutor was skilled enough, if I promised something or said something in opening, I couldn't back up during the trial, and I think I would lose point. I agree. The opening can and should be succinct. Now, the closing, you can go as long as you need to go.
Absolutely. And so with the openings, again, I'm going to have some catchy hook at the beginning that is going to be a running theme. And now I might not use that same consecutive use of terms throughout the trial in that same succession every time, But if there's a couple buzzwords, I'm going to use those buzzwords on cross-examination so that they're hearing it throughout, and then I'm using it again in closing. The other two things I like doing in opening is, we hear that reasonable doubt can be created through the evidence, the lack of evidence, and the conflict in the evidence. But again, I'm trying to bring that to life. So I started doing this thing with my hands where I'll show the jury. It can be created through the evidence, the lack of evidence, or the conflict in the evidence. And see, my watch will click a little bit, right? So again, it's getting something to trigger with the jurors.
I'm still in that also. I'm going to use that as well.
Please do. Let me know how it works. I think it works, but it just might be in my head. So I'm interested to see if someone else likes it. And then again, I'm doing that in closing, right? I'm driving it back. And I think it's just a visual that they can take back with them into the deliberation room. And then with openings too, like we talked about the brevity of it, but I'm still highlighting, like members of the jury, I want you to really focus when I cross-examine Officer Smith or whoever the officer might be. I want you to pay special attention to X, Y, Z. I try to highlight, I'll tell a short story, but I really try to point out what I want them to focus on throughout the trial, because then when that same moment comes up on cross-examination, or if it's a direct examination of my own witness, I'm going to signpost that to, again, get the jurors' attention, and then in closing, sew it all back together. So that's really the goal of openings.
So case number one, this McDonald's case, you go through the opening. I guess the best thing we can do is dive into the cross, because as a criminal defense attorney, that's really where you score the most points, is cross-examination of the state's witnesses. So take me through some of the actual cross-examinations you did in this first case that occurred in that McDonald's driveway.
Absolutely. So it was of the lead investigative officer who actually witnessed the crash and arrived on scene. And I'll start by going through, how they got on scene. And especially in this circumstance, I'm highlighting, well, you didn't actually get called out for a DUI investigation, right? You actually arrived on scene for a car accident, right? Right. Okay. And so not all car accidents are the result of someone being impaired, right? Okay, right. So again, I'm leading them right into all of the reasonable things that could have happened here that night. That's not our client driving under the influence of alcohol to the point that their normal faculties are diminished in some material respect. And then so I'll push through not only that initial act in their body-worn camera videos, I then transition into literally going through their report with them. Because as a criminal defense attorney, we have the ability to go through that with a fine-tooth comb afterwards and find each and every misstep. Like sometimes I'll find on a DUI form, they just checked, there was an accident, yes, no serious bodily injury, no death, and then it might say any indication of impairment, drugs, or alcohol, and then they're both checked no. Now, maybe that's because it's a form that was used from a previous arrest. Maybe the officer was lazy. Maybe they made a mistake. But ultimately, that mistake, that conflict in the evidence, I'm going to argue in closing, leads to reasonable doubt. So really pressing them as to why they did certain things, more importantly, why they didn't do some things. And then what I think sticks out so much, at least in the trials that I've done, is highlighting all of the things that cuts against impairment that my client did or didn't do, right? So a lot of times they'll say, oh, well, he wasn't able to find his driver's license immediately, or he wasn't able to find his registration immediately. I'll say, but Officer Smith, isn't it true that even after my client wasn't able to find and locate his driver's license in his wallet, he actually was able to go into either his center console, or maybe it's in his backpack in the back seat, or maybe it's in the glove compartment. He was able to go and locate it. Okay, so the ability and presence of mind to locate an item that is not in the place that it normally is, doesn't that cut against my client being impaired or showing signs of impairment? And again, most officers, most witnesses, when you're asking a reasonable question like that, are going to roll over and say, well, yes, it does, or they're going to fight back. And you probably have a similar mindset. I don't care which way they go, because it's going to play in my favor. So I think if you really ask the right questions, and especially asking reasonable ones, that you lead them. I always reference it as walking them down the plank, right? because if you just try to push someone all the way down, it's going to be difficult. They're going to resist. But the closer you walk them down, they either got to jump or they're going to be resisting at the end, and they're going to look crazy for not doing so. And then in closing arguments, like I say, members of the jury, you saw how defensive Officer Smith got when I was pressing him on an investigation. So I would say that's kind of the general approach that I took to that case, and really pointing out, especially in that case, like I said, it was a car accident. They did an accident investigation. They got some other information from some other witnesses. They came back to my client, and my client was just like, no, like you said, it was an accident investigation. I'm not doing anything else. And I think that frustrated the officers, and I think it threw them off their game, because let me tell you, Chris, not once did law enforcement say, hey, where were you driving from that night? Did you have anything to drink that night? Can you believe that? They never asked whether or not my client had anything to drink. Now, one officer did say that he believed he smelled marijuana coming from the vehicle. But they never actually specifically asked him about whether or not he had smoked, whether or not he has a medical marijuana license, whether or not any other individual was in the vehicle prior to him that may have also had marijuana on them. So to me, there was a lack of investigation. And just because there's a car accident doesn't mean that the driver of that car was under the influence of drugs or alcohol. And so I think the officers got frustrated. I think they were, probably pretty new officers. And I just think that when you rush an investigation, which I think is natural, right? Again, it's easy for us to call out law enforcement after the fact with it. But when you're dealing with someone who's resisting, who's being a little frustrating, you just want to haul them off to jail. And as I'll talk about in some of the other cases, that's the biggest mistake, because then I get to say, members of the jury, my cross-examination today was a longer investigation than Mr. Smith gave to my client before arresting him for these crimes. And I think that resonates.
Oh yeah, I like that. It resonated with me. I'm gonna have to go back and highlight all the points from you that I can use.
I appreciate it, man. Hey, I gotta get some game from you too, though. It goes both ways.
It's all available. Anything I know and have, I tell people I freely give it away. So how many officers do you take on during this trial?
During that one, I believe the state ended up only calling 2. And so again, those cases for you and I who make this about you, but I got to tell the audience, we talked the other day about all the murder trials you've done lately, right? And so when you and I have talked about murder trials, sometimes you're in trial for 5 days, you got 25 witnesses. For DUIs, it's much less witnesses normally, but that's why my crosses are so much longer, because ultimately I don't have as much opportunity to poke holes in the state's case in chief unless I'm doing that thoroughly through the 1, 2, maybe 3 officers that are ultimately being called by the state.
So let's go to how you close this thing out. Closing argument. What does the state say first round of closing, and how do you respond to that while telling your client's story?
So the state, especially in West Palm Beach, I used to prosecute there. I think they have a lot of these similar patterns that they train their prosecutors on. And sometimes maybe it just gets passed down from one prosecutorial class to the next, right? But ultimately, I know the state's going to argue that the refusal to provide a breath sample and that the refusal to do field sobriety exercises on the side of the road, they're going to argue as consciousness of guilt, right? So I set this up in jury selection and in cross-examination. So in jury selection, I'll talk about, and sometimes the state talks about it, I should say that. Sometimes I won't touch upon it. I'll use what the state did. But so in jury selection and then on cross, we'll talk about 2 things. One being, all right, if you are going into Publix, right, and you're going to step on that scale that's in front of Publix, are you going to trust the weight on that scale? And then you're going to hear, oh no, maybe I had a lot of food that day. Oh no, who knows if it's working or not, right? So then I'm going to talk about in closing arguments, members of the jury, this is a machine. Maybe they didn't want to provide a breath sample because they didn't trust the machine was going to output the correct information. Additionally, when talking about the breathalyzer, at least here in Florida, most of the time, that breathalyzer is being asked after an arrest, right? And so on cross-examination, I'm going to ask the officer, well, Officer Smith, if my client did provide a breath sample and they blew 000 2 times in a row, Would you have unarrested my client? They have to say no because they've already made the arrest. They've already transported them back to the station. And so that's why in closing arguments, I tell the jury, members of the jury, you heard Officer Smith say, even if my client blew triple zeros, they were not going to release him. They were not going to unarrest him. So my client felt like he had already been unlawfully arrested. He had already been taken off to jail. They already weren't listening to him. Why would he continue to do these voluntary things when it's not going to help him long term?
That's absolutely true. I'm going to jail no matter what. I'm done. I don't want to talk to you anymore. Still on case number 1, you do your closing argument. You guys are waiting on the verdict. How long does it take for the jury to come back with a verdict?
This particular one actually took about 7 hours, which was one of the longest I've ever had for any misdemeanor, but especially a DUI. I would say normally, as a defense attorney, the longer they're out, you're like, okay, we got some reasonable doubt. But then, especially in West Palm Beach, the judges stop jury deliberation like right at 5 o'clock. They do not want their courtroom workers and personnel there past 5 o'clock. It costs too much for the city. So they actually brought the jury back the next day. And I'd love to hear your thoughts on this. As a defense attorney for a case like that, I don't want the jury to go home. I don't want them to sleep on. I don't want them talking to their wife or their husband or their family about the case, even though they're not supposed to, right? That's my fear. They're going to look up something. They're going to talk to somebody about something.
You know my thoughts on that? I wish they did that here in Louisiana. Here, once the jury retires to deliberate, they cannot leave the courthouse. So I've been in waiting on jury verdicts. The longest one, they came back at 4 a.m. And I always say when the people get tired and are ready to go home, that doesn't work in favor of the defendant. That's my belief on that. They're going to rush and vote guilty, not rush and vote not guilty.
And that's where, like Tallahassee, I've done so many trials up there, they will keep you late. I mean, I've been there till 10, 11. And it's kind of up to each judge, and then the judge will check with the jury. But I'm with you. Like, I don't want them going home necessarily if I think we're close. But I also don't want them to be making a verdict decision because they're hungry or they're tired or they want to get home. So it depends on the case, I think.
So tell me what was going through your client's mind during this more than 7 hours. I'd imagine you counting 7 hours in the courthouse. There was some hours during the first day, and then he went home and had to sleep on it or not sleep thinking about it and come back the next day. So what was going through his mind during all of this, as far as you know?
He was just nervous and he was praying. I mean, he was a religious individual. I mean, he would just step outside and he was trying to remove himself. I just, hey man, you better answer your phone because if they have a juror question, we need you back in here. He was pretty quiet. You know, we would talk with him about what could happen if they do come back with a guilty verdict, whether or not they would remand him right away. You know, does he need to call any of his family? Does he need to get anything set up? Obviously, that's stuff we did before the trial as well. But again, just reassuring that he's got those checks and balances in place. But he was happy with our performance, and, you know, he just had to kind of trust the process. But I always try, as long as the bailiff allows it and our client is not currently, you know, incarcerated, normally they're allowed to walk freely about the courthouse. So I always tell them, go, please, go relax, go grab a Mountain Dew, go grab some Doritos, take a deep breath, try and escape it, because the last thing I think they want to do is sit in that courtroom. And then a lot of times myself, if I have a co-counsel, I know the prosecutors, I'm sure it's the same with you, and we're personable individuals. I want to talk to them about what's going on in their cases, but I also don't want to do that in front of my client. Just from sports, right? Like when we played Florida State, played against Miami, you know, in college, we all knew each other, right? Like there were guys we grew up playing football with in South Florida. But just because we know each other and we've gone to war with each other doesn't mean we can't go to war again right now. So I think sometimes clients forget that, but I like kind of removing myself from it as well. You know, immediately after, when the judge is still going through the jury instructions with the jurors before sending them back, I'm definitely still reeling. All right, what did I say? What did I do? What didn't I do in closings? But then once the jury retires, I try to also take a deep breath, step back from everything, and just try to, you know, eagerly await the jury's verdict.
One of the things I tell especially young lawyers when it comes to, it touches on something you said earlier. When it comes to closing argument, I do not write it out. I might write bullet points or doodle something just to trigger my mind where to go next. And I tell people, like, Everybody misses something. Every time you sit down, you say, damn it, I should have said this, or I left this out. But having that natural flowing closing argument is more important than having a 4-page letter that you're just reading to the jury. That's not going to get you very far.
Agreed. I'm the same way. As soon as I sit down, I think it's happened every trial I've ever done. I'm like, I thought about saying this, I didn't get to it. But sometimes it's not like, oh, I forgot to say something that was crucial to the case. It was like, oh, I kind of wanted to expound upon something with this like catchy thought that I had. But then sometimes you got to just feel the room, and like maybe you said something, again, since you and I don't write it, like sometimes I'll say something, I'm like, oh, that hit. Like I need to wrap it up. I need to wrap it up right now. Like I cannot do better than that. So sometimes I'm sitting down like, okay, I wanted to do that, but no, I think I did the right thing by sitting down when I did as well.
Yeah, sometimes you have to know when to shut up and sit down. So the verdict comes. Tell me your client's response when the verdict is read in court.
I'm strict on telling my clients I don't want a positive one, I don't want a negative one while the jury's still sitting there, right? I might have my hand, on the back of their arm or on their back, or just kind of tapping them legs like, hey, like remember what we talked about. So in front of the jury, we kept it pretty calm, cool, and collected. But as soon as they retired back to the deliberation room to get their stuff and leave the courthouse, just the overwhelming sense of relief. I mean, and disbelief. And I know we talked about this one for a long time. I apologize, but you'll hear it with some of the other ones. I had one of my clients literally look at me out of these three and said, wow, I thought that this stuff only happened in movies. Like clients are shocked sometimes when they're found not guilty. And so I think while people are excited, I think it's just been such a rush of adrenaline and emotion throughout jury selection, throughout the trial, that they don't even really understand what just happened until days later. And then I'll get a call or text and I'm like, man, that was unbelievable. I was just telling my girlfriend about what you did in there. I can't believe I'm guilty. Like it is happiness, but I think it's also confusion. It's just an adrenaline dump. I think it's a lot of things going at once.
I would agree with that. Sometimes they cry, sometimes they can't even get words out. Rarely is there like a large outburst by a person who's found not guilty. They're just relieved more than anything, I think, that they can get their life back. So let's go to case number 2.
Yeah, so with case number 2, again, this was a DUI with a refusal and a resisting without violence. I misspoke. That's the second refusal misdemeanor charge, right? And this one was interesting because this individual had been driving home, and I guess apparently law enforcement believed him to be speeding, right, but going opposite way on the road, right? So the classic, oh, I visually observed this individual traveling what I believe to be over 35 miles per hour. So then this officer went down the road, did a U-turn, and by the time he actually caught up to my client and activated his lights, it was as he was going into his condo, like into his apartment complex, right? So he's already at the gates of the apartment complex. There's an officer behind him. The officer puts his lights on. My client goes through the apartment complex. The officer's following him. My client parks his vehicle. And then right as he gets out of the vehicle, mind you, perfectly parks his vehicle next to a curb and in between the white line and the car to his right, which will become important in a moment. And he gets out of the vehicle. The officer says, he doesn't even say, hey, stop, I'm conducting a DUI investigation. He just yells, hey, stop, it's law enforcement, right? And my guy looks at him like, dude, I'm going home. I live right there. Now, again, I don't condone that. If a law enforcement officer is asking you to stop, now granted, sometimes law enforcement might be abusing their powers, but let Chris handle that afterwards. Let Paul handle that afterwards, right? Because it's only going to make a situation worse.
You're not going to win on side of the road. I tell people all the time, you're not. You're just not going to. I can't win on side of the road, so I'm not going to even try. You can deal with it later if you don't make things worse for yourself.
And then right away as he's walking, officer goes and tackles him to the ground, cuffs him, picks him up. Again, doesn't really ask him a lot of questions for a normal DUI investigation. Another officer arrives on scene. He has the other officer put him in the rear of the other officer's vehicle. And then that's when the officer asked this completely independent witness who I think was walking his dog or coming home from the gym, like, hey, did you just see what happened? And, got a statement about him walking away from the commands and the tackle. So now the whole investigation kind of shifts towards the resisting without violence, right? And then the initial stopping officer begins to search my client's vehicle. Now, again, under SILA, search incident to lawful arrest, I get it. You think that he might be impaired, looking about the front of the vehicle for any containers of alcohol, any drugs, all for it. He takes my client's keys, though, and pops his trunk. And I'm like, what are you doing, man? Like, you had no reason to be going through his trunk. There was no evidence of any crime or any drugs. You did not have probable cause, in my opinion, to search it. And even more so, they were not impounding the vehicle. They were not towing the vehicle because it was at his apartment complex, at his house. So they did not need to do an inventory search either. So had they found drugs or weapons, we would have had an amazing motion to suppress because that was an unlawful search, in my opinion. But then the officer, I think, again, is frustrated that my client resisted. So he had the other officer transport him to the jail. And not until they were outside the gate of the jail did the initial stopping officer approach my client and tell him that he is doing a DUI investigation. And again, at that point, my client is literally looking at the walls of the jail. And he's like, I'm not doing anything. Take me in, whatever. And so again, I think the officer failed to conduct a proper DUI investigation. And I think that it really sucked a lot of the wind out of the sails of the state's argument that the defendant willingly and knowingly and voluntarily refused to do these voluntary field sobriety exercises and provide a sample. Because the consciousness of guilt didn't look like, if they were still on the side of the road when it first happened, I think that consciousness of guilt argument for the state drives home a little bit more. But here, it was like, you're asking him now after you already cuffed him and transported him? Like, why would he do that? It's not consciousness of guilt. That's just, hey man, my night's done. You already got me here. We're done. Like, that was really the start of it. And as I've kind of pointed out, some of the focus points as we'll go through the trial.
Let's start with the opening. We know how you like to prepare. You figured out your closing argument. I know jury selection is virtually identical in a lot of these cases. So let's go to your opening statement in case number 2.
So in case number 2, they actually brought forward the second refusal charge, and they brought forward the resisting without violence charge, right? And so I told my client, I said, listen, man, I'm going to be honest with you. I'm not going to, in opening, fall on the sword and say you're absolutely guilty of resisting without violence. But let's be real. You are driving away from law enforcement with lights on in your apartment complex. We can likely make valid arguments and reasonable arguments that, hey, law enforcement, whether they were going to your house or a neighbor's house, they had to go through that same entrance that you did to the apartment complex. So I think there were reasonable explanations as to why he continued driving through there. But the moment when we see on dash cam and body cam, officers saying, sir, stop, law enforcement, and he walked away from them, I'm like, man, it's going to be hard to really do that. So in openings, I really focused. Again, I didn't fall on the sword for the resisting without violence, but I really focused the opening on picking holes in the lack of the DUI investigation, and that the officer rushed to judgment because he was frustrated again with the resisting.
So we get there and they call these officers. I want to know how you deal with them on cross.
So this officer was extremely nice, right? And I think you probably agree with me since you're a seasoned trial attorney. Sometimes the nice witnesses are good, but sometimes it really messes up our flow, right?
Like who wants to fight somebody who won't fight back?
I was amped up. I was ready to really put this guy through the ringer for all the missteps that he had. The aggressiveness to tackle my client initially, the quickness in which he rushed him off into the backseat of another deputy's cruiser without going through any of the DUI investigation, and then the shortness and the argumentativeness on the drive over, and then ultimately when he was asking whether or not he would submit to any field sobriety exercises outside the jail. But I'm telling you, man, it was like, I'm just going to keep saying Officer Smith so I don't name any officers, right? But it's Officer Smith. Isn't it true that you did not ask him a single question about driving under the influence until you actually got to the jail, which was 30 minutes after the initial traffic stop? Yeah, that's true. He was just rolling over on these questions I thought would have some pushback, but also I felt like it came across to the jury as like, hey, listen, this officer is kind of owning up for his lack of investigation. So this cross actually was much less contentious than the first trial, but it was methodical, again, in going through all of his reports, the lack of information in a lot of the reports, and ultimately, I also focused on, just because someone is being an asshole doesn't mean they're committing a crime. And so I try to bring that out on cross-examination and get the officer to admit that my client's, negative behavior was frustrating him, because I want that for closing arguments, right? And then again, I really kind of stayed away from the resisting, just because I knew in closing arguments I would be basically falling on the sword for the resisting, because that was going to be a small misdemeanor. It wasn't going to have any jail time. And as we commonly refer to, I'm sure you say something similar, we say juries like to split the baby. And so out of the two charges, if I'm going to have them find him guilty of one of them, I want it to be the one that doesn't have driver's license suspension implications, the one that doesn't have jail implications. And so ultimately, that was really the focus of the cross. And then I made sure to pull up multiple portions of the state's videos that were in evidence, even on cross-examination, to get the jury to see and hear this officer's live time reaction to my difficult questions as to why we can't see the evidence here. Why are you pushed him out of the camera sight here? So things like that.
I think one of the things you said, and it's a lot of times we have to get this point across to clients, is that you have to maintain credibility in the courtroom. So if there's a charge, especially a minor charge where they clearly have you, sometimes people are more believable when, let's say you're accused of 2 or 3 things and you said, I did that, but those 2 I didn't do. That's much more believable than I didn't do any of it, especially if they have you dead to rights on one. You better be prepared to fall softly on that mattress while I try to save you from busting your head on this concrete. Look, credibility of the lawyer, the client, all of that sometimes requires us to own up to some things. Now, if it's like a murder case, or even like you say, the second refusal where the client is going to have serious consequences with any kind of conviction of the charge, then you got to kind of fight the fight no matter what. But yeah, so we go through that. You deal with the officers on cross. How does the prosecutor close, and how do you respond to their closing?
The prosecution, I thought, put too much weight into the resisting aspect. Because again, I was going to fall on the sword of resisting, but that's where us going second, I think, helps us, right? Because not only do I think they were focusing too much of their initial closing argument on the resisting without violence, I also thought they tried too hard to use the resisting as evidence of impairment. So I felt like they were really kind of overselling their case and somewhat losing credibility, to your point, because ultimately when I got up there, I said, members of the jury, and I went through the whole thing about the evidence, the lack of evidence, the conflict in the evidence, went over what their burden is. And I said, members of the jury, maybe the state met their burden for resisting without violence, but there is no chance that they met their burden for the subsequent charges. So that's where I think that gave something for the jurors to latch on to, that the state had just argued heavily, and that I was able to say, fine, you're right, that is beyond a reasonable doubt for that. But if that's beyond a reasonable doubt for that, there's no way the rest of this stuff can be beyond a reasonable doubt, because you do not even have close to the amount of evidence that does. So that was really my approach for that one, which was different than case number 1.
What was the verdict?
Not guilty as to the second refusal, and then guilty to the resisting without violence. So they came back exactly as I like to. And then what's great about that is, with that, because they can't try the second refusal and the DUI at the same time, because it's prejudicial for the jury to hear that they've previously refused a breathalyzer for that DUI. So then what happened of getting that not guilty on the big charge, the state then said, well, if I can't even prove, and so I think it's important to spell out the elements for the listeners. So for a second refusal, one of the elements that the state has to prove is that the officers had probable cause to make an arrest for a DUI and subsequently ask for that lawful test of their breath. So even though the charge is second refusal, one of the elements is proving that the officers have probable cause for a DUI. So then what we do is we argue to the state after that, hey, if they can't even find that the officer had probable cause for a DUI arrest, how are you ever going to prove beyond a reasonable doubt in a subsequent trial? So then from there, the state dropped the DUI down to reckless driving and just ran it concurrent with the probation he was already going to be put on for the resisting without violence. So we were able to, with that not guilty verdict, get the big DUI completely dropped. No longer has a conviction for a DUI on his record. No longer has an additional driver's license suspension on his record. Won't impact his insurance the same way. And a lot of employers nowadays really look negatively upon DUI. So it was a massive win. And again, like you said, we had credibility with the jury because we were willing to fall on the sword for the resisting. And like I said, on video, officers giving lawful commands, he's ignoring them and walking away. Like, dude, I might not agree that that should be a charge, but it fits the element.
It fits this legal definition in this big book we have to walk around with. Look, we don't agree with a lot of laws that are in there, but we're not writing them. The legislator is, and sometimes I don't think they have a clue what they're doing. Your client's reaction to the verdict, what was it?
He was feeling pretty confident when the jury was deliberating because even before the trial, I told him, and again, a big phrase I always use is, I don't want to overpromise and underperform. I'd rather underpromise and overperform. But when it comes down to like day of trial, that is when I'm empowering my clients a little bit more. And I also, though, try to set reasonable expectations. And I told him, I said, listen, man, I think we're winning on this second refusal, which is going to get them to move off of that other DUI charge. But I think you're going down for the resisting. And as the trial was moving forward, he was passing me some notes. I'm big on, confirm with co-counsel, confirm with my client after every witness. So I knew that he was satisfied with the work product that had happened throughout the trial. But he felt good, and he definitely left the courthouse pretty excited that day.
I have a case very similar to that. Several years ago, we represented this gentleman. He was charged with possession of a key of cocaine and drug racketeering. And the drug racketeering carried up to 50 years in prison. And when the officers arrested him, he had the drugs tucked. They were just right here under his shirt. So almost immediately, I don't remember if we did it in jury selection, but certainly an opening statement, we kind of fell on the sword. We owned up to the possession. I mean, it was kind of hard not to. The drugs were on you when they arrested you. But the racketeering charge, we fought it tooth and nail, and he was found not guilty on the racketeering charge. And he was found guilty of possession, which, was significantly less jail time.
Absolutely. Good work, man. That's great.
But that's that credibility deal. You go in there, you lose all credibility if you say, this cocaine that's under my shirt, I didn't know it was there or it's not mine. I mean, it's not going to work. All right, so now we got this third case. Case number 3.
This third one was one of the ones that we actually got connected on initially about because this to me was a prototypical DUI that you would get from a probable cause standpoint. I really went through the videos. That is when the whole case opened up to me. So this individual was driving home from a work party, right? So he's dressed up nice, right? He's got a suit on. It's like it's a weekend night. But it's not like 2 a.m., right? And that was the other thing that I kind of liked. It was closer to like 11, 12. So it's still a reasonable time to be leaving a work event. Officers say that they see him speeding. And so we start to see the dash cam as he's starting to catch up to my client. It's listed in the report that my client is parked over the white stop bar, right? At the red light. Now, normally at most intersections, if you're stopped over that white bar, that means you're in the crosswalk. What was crazy about this intersection, and I've never really seen another one like this, between the white stop bar and the crosswalk where pedestrians could walk was a full car length. So even though my client's car was over the white stop bar, he had tons of room in front of him before the crosswalk, and that was something that we focused on in cross-examination. Any reasonable, sober individual would have seen the crosswalk and stopped before that. You see in the video, he does come out of the red light, with some speed. Then as soon as the officer lights him up, he puts on his left blinker, makes a proper left turn, pulls down a side street, and then parks his car parallel to the grass in front of a house. And so he didn't park on the grass. He didn't park crooked. He parked perfectly straight. And then, the normal things, I'm reading the probable cause affidavit, you're hearing or you're seeing, okay, we went up to the car. We saw a can of beer in the car. Client says he's coming from a work party. Client refuses, taken to jail. Okay. So you read the probable cause and you're like, I don't really like this. He's speeding past the stop bar. There's a beer can found in the car and a work party late at night. I'm like, oh man, it's going to be tough. Let's jump in here and see what we got. And the probable cause couldn't have been more different than what I saw in the videos, right? Because again, the stop bar and the crosswalk that I just explained, that wasn't indicated in the probable cause affidavit.
Of course not.
Exactly, right? They didn't talk about the perfect left turn he made, the parallel park he made on the side of the road in front of a house next to grass. Yes, while they found a can of beer in the car, they never collected the can of beer. They never collected it. There were not photographs of it. The officers couldn't even tell us whether or not it was cold to the touch, whether or not there was any beer in it. I mean, they had almost no information. And that can, when we saw it on video, was also on the ground with tons of other energy drink cans, right? So it could have been there for a week, could have been there from 2 hours ago. It could have been a different passenger's beer can. And ultimately, when they're asking my client questions, he is answering calm, cool, and collected. He's answering everything they're asking him. He's not being difficult. He provided them with everything. And then a second officer arrives on scene. And again, it's not in the probable cause affidavit, but I was going through the body-worn camera and of both officers. I started hearing from the female officer some statements. I was like, what is she saying? And then I was able to listen to the male officer's body-worn camera that was on when he was in his cruiser. And when I started putting them together, I got a better understanding. So the male officer was the one that initially pulled him over. The female officer that came on the scene afterwards, she was more the lead DUI investigator. And she literally comes up to the window and is like, what we got going on? And he's like, I might just let him go, but he lives down in Boca, and I don't want to wait for someone to come pick up the car. And so she goes, well, let me go talk to him. Let me ask him some questions. I'm like, did I just listen to what I thought that the initial stopping officer who first made contact with him, who saw all the driving we've already discussed, literally said, I was just going to call his friend to come pick him up. I just don't want to wait that long since he lives in Boca. And then ultimately the female officer arrests him for DUI. So the theme, and I might not have it verbatim now, it's been a few months, but in opening and closing was two different officers with two differing opinions as to what should happen to my client on X and such date, and only one verdict that you all should come back with, right? Because, and then in closing, that's when I really hammered it. If one of the officers on scene did not feel the need to arrest him, which is at that lower probable cause standard, how in the world could 6 jurors come back beyond a reasonable doubt that it was a DUI? So that was one of those cases where I found gold, like a little gold nugget, just sifting through these videos. And if you didn't listen to both body-worn cameras in its entirety, it was just the two officers talking back at one of their vehicles with the offhand, like, I was just going to call one of his friends, but I don't want to wait. And that just drove home, and we just kept arguing with the jurors and closing. Like, members of the jury, if the officer had a little more patience and wanted to wait, you wouldn't have all had to wait downstairs in the jury selection room all day. We had a field day with that, man.
How were those officers under cross-examination?
I was surprised that the male officer, so I had a co-counsel on this case, right? So I did the closing argument and the lead DUI investigators cross-examination. But this was a case that one of my good friends, Kevin Peterford, he's a former prosecutor. We used to prosecute together, and now we get to try some cases together, right? So the male officer, and he also did the opening. So we kind of split all that up, right? And so with this case, the male officer, I guess, had known Mr. Peterford maybe for some previous cases. And so I think he was trying to puff his chest out a little bit at Kevin and was trying to, make sure he looked as good as possible. And he was fighting some of that stuff a little bit too much. So I was surprised with that. And then the female officer on scene, there were times where she got a little attitude with me on there, which I liked. But overall, I think she tried to over-explain, kind of opposite from the other trial I talked to you about where the officer was just rolling over on stuff. She was really trying to force like her position on this case. And even when the questions didn't require that response. So to me, it became readily apparent that she was really trying to oversell it. And then the state, once they caught on to our theme and kind of what we were trying to do, was trying to draw out how this female officer was the one with more experience. And so she's the one that should have been on scene to make the decision. And I think it just developed too late for the prosecution because by then the witnesses had already kind of testified. You couldn't really recall one of the witnesses. And it was just, the officers were kind of trying to point the fingers at each other. And we kind of knew that that might happen. And so if the female officer is supposed to be the lead DUI officer, well, she didn't see any of the driving pattern. She didn't see any of the things that the male officer, in essence, they were kind of tossing away some of the key evidence and interpretations of the male officer by trying to build up the female officer. So I just think we caught them so off guard, and maybe I really don't think the state ever heard those statements that were made. And if they did, I don't think they connected and understood the significance of one of the on-scene initial stopping officers wanting to let our guy go.
That's what you truly highlight is that as the lawyer, the defense attorney, you really need to listen, read everything, but any kind of video they have, you need to watch it because a lot of times they'll write stuff in the report that it's not what you hear on the audio or the video. I had a trial once where my client, he shot a guy. And the police report, I'll never forget, the police report says they asked the client what happened. And the client, in quotes, in the police report, in quotation marks, the client responded, "I did what I had to do." Now that sounds really bad until we actually listen to the body cam and the client says, "He had a gun, I had no choice but to defend myself." Much different than I did what I had to. So yeah, he did what he had to do, but that's not what he said. That resonated with the jury. Back to this client, what's his response when that jury verdict finally comes down?
He was the one that I was alluding to earlier where it was like, I thought this stuff only happened in the movies. Like that's what he said to me. He was so shocked. And I'll tell you, as we were working this case up and as we were getting closer to trial, this was also the individual where we busted the first jury panel. His patience had worn thin. I mean, he was done. He had gone to so many court appearances, went through a full jury selection. We didn't get the jury panel. So I think he was just in a complete sense of shock and disbelief that like our advice really did pay off for him because he was close to wanting to take a plea. And again, if a client wants to take a plea, that's their prerogative. But us as good defense attorneys are going to talk with them about the pros and cons. And had there been a really good plea offer, maybe had they offered a reckless driving, I would have told them, hey man, like that's a good guarantee. I still like our chances in trial, but I don't blame you for wanting to take it. With this one, I looked at him and was like, brother, I promise you, this is not a good enough plea deal to take to give up your chance at trial. And we knew the judge is a former public defender. So we felt pretty confident that even if this didn't go the way we thought, he's basically going to get the same sentence from the judge as the plea offer.
I had one last year. A client was charged with manslaughter. And here in Louisiana, manslaughter carries up to 40 years in prison in Louisiana.
Wow.
There's an enhancement if a firearm is used, which tacks 15 onto that. So my client, we go to jury selection. He's charged with manslaughter. I actually brought my daughter who was a sophomore in high school. I think she might want to be a lawyer. She has 2 older brothers. They're not going to do this. So I brought her to the trial. We're in jury selection. And I asked the jury veneer, what are the thoughts that went through your head when you heard this young man was charged with manslaughter? And one of the deceased guy's family members screams out, it should have been murder, not manslaughter.
Oh my God.
So I move for a mistrial. The judge grants it. and we're getting ready for the next trial. And my client, his anxiety, his nervousness was through the roof. And he called me. He was like, Mr. Chris, I'm taking a plea deal. I'm not going to trial risking 40. And I think the judge gave him 12 or 15 because they wanted him to plead open-ended to manslaughter. I was like, I'm not doing that. Like, it carries too much time. I'm never going to agree to plead this 17-year-old kid open-ended to manslaughter. We got them to agree at a cap of 15. So the judge had from 0 to 15 to go, and the client was okay with it. It was a case I really wanted to try. I really thought we had a good chance. The deceased guy had shot at somebody earlier with a shotgun. And when my client shot and killed him, he was found with a shotgun in his, laying next to his body. The same shotgun. And, I thought we had a really good chance, but I don't get to make the final call because it's not my life and liberty that's at stake. So my client took a plea, and I get it. Having to get up to do it more than once is already hard enough on our clients, but having to do it more than once is almost unreal.
Oh, I couldn't agree more. And what I've always said, even when I was a prosecutor, is like I've always felt like slam dunk cases either which way really shouldn't be going to trial. Like I get it. Sometimes I talked about like certain cases sometimes have to go because there's no plea offer, and I get it. But so many cases I feel like should have been resolved. And because like if I think I'm going to slam dunk win, it should be dropped. If the state's going to slam dunk win, it should be a plea deal. And so that's why the real good trial cases that are supposed to go to trial, I love those. And so when my clients start to get scared, my job is to let them understand that's why you have me. That's why you have pushed it this far. But I always tell them, hey man, it's not about what I want, because at the end of the day, I'm going to go home. I'm going to come back. I'm going to come to my desk the next day and have more cases to work on. You might end up in custody. So I get it. You have to make this decision on your own. But ultimately, I'm never going to unduly influence, but I also am going to tell them, because I have a good memory, right? So a lot of times these clients are like, from the moment they hire me, I want to fight this. I want to go to trial. So then I remind them, hey man, for the last 8 months, you've been telling me you don't want a plea deal and you want to take this thing to trial. So what changed now? And then if they're explaining to me, well, the prosecutor didn't want to budge, that must mean they have a good case. And I was like, well, let me just tell you, as a former prosecutor, it doesn't necessarily mean that they think that they're absolutely going to win, but because of your priors or because of the office policy, this is the best deal that they can give us. So you can either take this deal or we can go. And if they really ask me, and again, like you said, we can't give percentage chances. I always find that funny to talk to with clients because they're like, well, you think it's greater than 50%? I'm like, listen, I can't do that. Like, I can tell you that I like our chances based upon this piece of evidence, this lack of evidence. Okay, so like greater than 50? Sir, ma'am, I cannot say that. It's the balancing act of telling them, I like your case, we got some strong points, but without making any improper promises to them.
Right. Well, I certainly appreciate you doing this. I think every person that watches this will have a mountain of information on what to do if they're ever on side of the road and being investigated for a DUI. And that's just not Florida. Anybody in Louisiana and probably the neighboring states, you gave a lot of golden nuggets that they can use. And any lawyer that watches this, look, I made notes of some of your strategies and techniques that I can take away and use. So I know that any lawyer that watches this is really going to, learn a lot and get a lot of valuable information and insights on how to defend DUI cases. But some of the stuff you said, it can be literally used to defend any sort of criminal case. So before we go, I want you to tell people how to get in touch with you if they ever need your services.
Thank you so much, and thank you for having me. This has been amazing to speak with you about, especially someone as experienced, as knowledgeable, and as hungry to be in trial as I am. It's great to see a similar mind like that. Overall, I'm at the law office of Rubin & Rubin. I joined here as a shareholder in January of 2024. So our main office line here is 772-283-2004. My email here at Rubin & Rubin is the letter P as in Paul, my last name, Aloise at RubenandRuben.com. So P-L-O-E-C at RubenandRuben.com. You can find me on social media. I'd say I'm biggest on Instagram. My name, Paul, P-A-U-L _ my last name, Aloise, A-L-O-I-S-E. I have a sports and entertainment legal page that I work to as well. So if you find my name, you might find 2 pages, but feel free to follow them both. One has all general trial success, and then one's more just on the sports and entertainment stuff. So yeah, anyone that has any questions, feel free to reach out. Chris, always a pleasure to talk with you, and please let me know how some of those things work when you're in the courtroom.
I will do that. Thank you. It's been a pleasure, man.
Absolute pleasure, man. I love what you're doing with Iron Gavel. You got a great following, and I know it's just going to continue to grow. So thank you for allowing me to be a part of it.
Anytime, man. I might have to bring you back later in the future.
Hey, just let me know when. I'll be there.
All right, great. Thanks. Enjoy your Friday.
Yes, sir. You too.
All right, take care. Thanks again for joining and watching this episode of The Iron Gavel. Please remember to hit the like and subscribe button and follow me on YouTube, Facebook, Instagram, TikTok, LinkedIn, all these platforms. We're there. This episode provided invaluable information for anybody that may be facing a DUI and any lawyer who may be defending a DUI. Listen carefully, folks. Take notes, and I'll see y'all in the next video.